Good morning, one and all present in this august house today. I, Niharika Tiwari, will be presenting my point of view on the topic: is judiciary interfering into the domain of executive? If so, is it permissible under our constitution? Well, the answer to that question will be yes, but it's not actual interference, but a power vested with the judiciary to safeguard the fundamental rights of the people of India, known as judicial review. So what is judicial review? It is a scrutiny by the government, by the other acts of the government, to ensure that they act within the limits of their competence as drawn by the Constitution. So my purpose in this regard would be to examine the Indian experience of judicial review and the changing perception of judiciary in Indian democracy. This topic directly points towards judicial activism and its legitimacy. That is, when is it activism? When is it excessivism? How do we draw the line? In Empress versus Brahm and Book Singh, the Calcutta High Court enunciated judicial review as follows. The theory of every government with a written constitution forming the fundamental and paramount law of the nation must be that an act of legislature repugnant to the constitution is void. If void, it cannot bind the courts and oblige them to give it effect, for this would be to overthrow, in fact, what was established in theory and make that operative in law, which was not law. In A.K. Gopalan versus State of Madras, the courts held that the power of judicial review is inherent in a written constitution, and therefore the provision in Article 13, Clause 2, that is, any law inconsistent with the fundamental rights will be void, was brought by way of abundant caution. The strategy adopted by the courts in this case was positivist, as they did not give wider meaning to words like procedure established by law or personal liberty in Article 21. 1967, Supreme Court in Golaknath versus State of Punjab held that the Parliament cannot pass any amendment that abridges the fundamental right of the people of India. They brought the natural law concept to understand the position of fundamental rights. Then we all know what was the manifesto of the Congress party in Mrs. Indira Gandhi's government. They introduced a 24th Constitutional Amendment Act that empowered them to take away the fundamental rights of the people, as it restored to the Parliament the unqualified power of constitutional amendment. Even they were able to suspend Article 21, that is right to life and personal liberty. This was challenged in Quechua Nanda Bharti versus Union of India, where the Supreme Court held that the power of amendment is not unlimited and Parliament's power under Article 368 is restrained by the inviolability of the basic structure of the Constitution. The fundamental rights were kept in mind in this place. It was a continuum of the doctrine of unamendability of the fundamental rights. The Supreme Court is the protector and the guarantor of the Constitution and the fundamental rights of the people of India, most of whom are ignorant and poor. This is why the liberalization of the rule of locus standi became necessary, and this is when PIL, public interest litigation, originated. It all started with Sunil Batra versus Delhi administration, where the courts responded to a letter written by Sunil Batra, a prison inmate, which drew attention to the miserable conditions of the prisoners. After the liberalization, the social action groups were able to represent the disadvantaged section of the society in the court. The courts appointed lawyers as amicus curiae so that they can draft regular petitions based on the letters. Quoting Justice Bhagwati in Bandhua Mukti Morcha versus Union of India judgment, it must be remembered that the problem of poor which are now coming before the court are qualitatively different from those which have hitherto occupied the attention of the court and need different kinds of lawyering skills and judicial approach. From declaring a 1400-year-old practice of talaq-e-biddat unconstitutional to upholding privacy as a fundamental right, forcing the street citizens to stand for national anthem in cinema halls only to retract later to say that one does not need to wear patriotism on one's sleeves. This was all possible because of judicial review, because laws also have to adapt to the changes that are happening to evolve the society. At the same time, there are instances of excessivism that fly in the face of doctrine of separation of powers, but the political players as well as the people in general also feel that where matters of conflicting interests are involved, the courts are better arbiters than the politicians. Also, we have to accept that judges are human beings as infallible as other human beings are. That's why they have imposed restrictions on their own powers so as to ensure and minimize such subjective lapses. This is how the courts maintain their legitimacy. Thank you.